of the dais, I, Prachi Bhardwaj, on behalf of EBC feel deeply honored to welcome you all on this momentous occasion where we gather to release Money Laundering Prevention, Law and Practice by Mr. Abhijeet Sharma. Published by EBC, this book delves into the complexities of this issue, offering insights into the prevention of money laundering, international efforts to combat it, and emerging concepts such as cyber laundering and digital payment system. The release of this important book. Allow me to first welcome the dignitaries on the dais. Introducing Justice Ajay Rastogi, a distinguished legal luminary with an illustrious career spanning over 4 decades. With a robust foundation laid in 1982, upon joining the bar, he honed his expertise in constitutional, service and labor matters. Justice Rastogi's journey includes serving as the Standing Counsel for the Rajasthan High Court, President of the Rajasthan High Court Bar Association, and leading the Rajasthan Legal Service Authority to prestigious national awards for 3 consecutive years. As a judge and acting Chief Justice of Rajasthan High Court, Chief Justice of Tripura High Court, and later in the Supreme Court, Justice Rastogi has delivered landmark judgments on crucial issues. Justice Rastogi's influence extended beyond the courtroom as he spearheaded digitization efforts at the Supreme Court. Known as the Master of the Greens for his prowess on the golf course, his pragmatic approach and compassionate demeanor have earned him widespread acclaim. Sir, we are honored to have you here as our chief guest today. I would like to request Ms. Bhumika Induria to felicitate Justice Rastogi. Experience and expertise to the legal realm. With a notable background as a senior standing lawyer for the Income Tax Department for 17 years, Justice Jain has extensive experience in constitutional, corporate, taxation, economic offences and arbitration matters before his elevation to the bench at the Rajasthan High Court. Justice Jain graciously provided for the foreword of the book, underscoring his commitment to legal scholarship and intellectual discourse. Did you all know that Justice Jain is also a chartered accountant, adding another layer to his impressive credentials? It is truly an honor to have you here with us, sir. I would like to request Ms. Nirupa Bhateja to felicitate Justice Jain. Illustrious Justice M.N. Bhandari, a distinguished legal luminary with a rich and diverse background. Originating from Rajasthan, Justice Bhandari's journey has been nothing short of remarkable, culminating in his tenure as the Chief Justice of Madras High Court. With a distinguished career that includes serving as a judge in both Rajasthan and Allahabad High Courts, as well as holding pivotal roles like Chairman of the UP State Legal Service Authority, Acting Chief Justice of Allahabad High Court, and Chief Justice of Madras High Court, Justice Bhandari is currently serving as the Chairman of the Appellate Tribunal, SAFEMA and PMLA. His esteemed presence adds an extra layer of significance to this special occasion. We are honored to felicitate Justice Bhandari. A lawyer's role is not just to win cases, but to ensure that justice is served for all. Our next guest, Mr. Rajdeepak Rastogi, exemplifies the true essence of the legal profession. Mr. Rastogi's exceptional career trajectory, marked by his multiple reappointments as Additional Solicitor General, Rajasthan High Court, speaks volumes about his steadfast dedication to the cause of justice. Known for his humility and approachability, Mr. Rastogi brings a wealth of experience to the table, particularly in matters concerning money laundering. Mr. Rastogi's unwavering commitment transcends mere case victories. His primary focus is on ensuring that justice is served for all, which is also evident in his humanitarian work. Sir, it is a privilege to have your presence today. I would like to request Ms. Mamta to felicitate Mr. Rastogi. Allow me to now introduce Mr. Surendra Malik, the Chief Editor of Supreme Court Cases, a relentless individual with an unparalleled workmanship. With a steadfast commitment to excellence, ethics, and fairness in his work, Mr. Malik has earned an enviable reputation for Supreme Court cases as the most accurate and reliable source of law reporting in India. As a torchbearer of EBC, established in 1942 by his uncle and father, Mr. C.L. Malik and Mr. P.L. Malik, Mr. Surendra Malik has upheld a legacy of over 53 years, ensuring stringent quality control over EBC's publications. Even after all these years, if asked about his retirement plans, Mr. Malik would probably smile and say, "I'm not doing a job." It is an honor to have you here with us, sir. I would like to request Ms. Dimple Lodha to felicitate Mr. Malik. It is with great honor that we now introduce the brilliant Mr. Abhijeet Sharma, Advocate, Rajasthan High Court, and the esteemed author of the book that has brought us together today. Even during his time as a student at the National Law University, Jodhpur, Mr. Sharma not only demonstrated a passion for writing, but also earned recognition as the youngest individual in the country to successfully draft, argue, and succeed in 2 PILs before the Rajasthan High Court, receiving commendation for his meticulous research and dedication. He even accomplished the remarkable feat of writing his first book at the age of 23. Mr. Sharma's work in this book, his second, promises to enlighten and inspire us all. I would like to request Ms. Shraddha Sharma to felicitate Mr. Sharma. A warm welcome to all our dignitaries on the dais and also to all our guests. I would now like to invite Mr. Surendra Malik to deliver his welcome address.
I'm delighted to be in this beautiful city of Jaipur, and on behalf of EBC Group and myself, with great pride and privilege, I wish to welcome Honorable Mr. Justice Ajay Rastogi, former Judge, Supreme Court of India, Honorable Mr. Justice Jain, Judge of the Rajasthan High Court, who has also been very gracious enough to provide a foreword to the book we are about to release today. Honorable Mr. Justice Bhandari, Chairman, Appellate Tribunal, SAFEMA and PMLA, and Mr. R.D. Rastogi, Additional Solicitor General of India at Rajasthan High Court, and our author, Mr. Abhijeet Sharma, Advocate, Rajasthan High Court. Judges, honorable members of the bar, ladies and gentlemen. In my view, there are 3 constants in the daily newspapers: PM Modi, Rahul Gandhi, and PMLA/Enforcement Directorate. So in a way, we are all very well aware of what PMLA stands for, and perhaps, though it is not designed, we also know that it is not designed for the crime itself, but against the proceeds of crime. Serious crimes of far-reaching implications for economy, financial system, and society at large. The crimes are listed in the schedule of the Act and relate to organized crime, terrorism, banking and financial frauds, economic offences, securities and insider trading, corruption, real estate, tax fraud, import-export, etc., etc., which basically affect the economic and financial health of the nation, and the actions are taken in the interest of the public at large. Among the acts listed in the schedule are two acts, the Copyright Act and the Trademark Act, which are of particular interest to me as a publisher because they hurt my best authors financially through piracy. That is covered in the Copyright Act section 63. The authors really work hard to make their works the best, and once their books become popular, they get hit by piracy. Such is the paradox. There is one more aspect which is a matter of some concern to me, that if students of law who come to study law, study counterfeited, pirated books to score in the exams, what respect of law will they imbibe, seeing such blatant violation of the law before them? This, I believe, is something somewhat worrisome, for it also reinforces plagiarism in the campus and with the chalta hai attitude. For one thing, all the big frauds by big people may not be evident till they come into limelight, but piracy of books is in the open for everyone to see. At least in Delhi, on traffic light crossings, you can see so many pirated books being sold for half price or even less, which is enough proof that they are all pirated. Now that even though piracy of books is quite rampant, in my view, it is unlikely that it would attract the attention of the government, which is primarily after big crimes by big people and syndicates. So for me, the question was whether the enforcement agency under PMLA can be activated by a private party. And in this respect, I find it fascinating that Abhijeet has been sensitive to this issue and has dealt with in his book. Surely enough, contrary to the general view against filing of private complaint under PMLA, Abhijeet has been able to find a High Court judgment in Gaurav Kathuria of the Punjab and High Court, which holds that a private party can move the machinery of the PMLA provided it is filed not as a writ petition but in a different manner. On page 36 of the book, Abhijeet has cited from the judgment, and I read, merely on receipt of complaint of money laundering from a private individual, the investigations cannot be directed by a court or commenced by an authority under the PMLA unless the scheduled offence is registered under section 154 CRPC and a report thereof is sent under section 157 to the magistrate, or a complaint is filed for taking cognizance of the scheduled offence by an officer authorized to investigate the scheduled offence. Later he says, it is further held that subject to compliance with the overriding provisions contained in PMLA and the rules made thereunder, even in PMLA there is nothing which bars setting of the criminal law into motion by any private individual by making a complaint either to the authority under PMLA with the prayer to commence the investigation, by registering a case under the provisions of the code, or to the jurisdictional magistrate for seeking directions to to the authority under the PMLA for investigation, unquote. I think Abhijeet, by including this ruling in his work, has done human service to all the authors and artists engaged in creating literary, artistic and musical works who suffer due to their works being pirated at such large scales. What is personally of satisfaction to me that in this case, in the book, it bears the citation of SEC Online, namely 216 SEC Online, PNH 3428. To go back, the EBC group has been engaged in disseminating legal information for more than 80 years since 1942. Today, in an age of overwhelming legal information, most of which is free, our focus now is also to provide the means and tools for easy and quick access to the law. The law that is required at a particular moment by the lawyer and the judge. What will be sought for is that only the law relevant to the issue in hand and the way the legal system works, in my understanding, that one is expected to carry to the court the latest and the most important rulings with the assurance that it has been selected after exhausting the law, meaning that the entire body of case law has been considered to reach that latest view or the most relevant view. To get a perspective, till the last count, SEC Online had more than 500 databases, 55 lakh documents, covering some 2.75 crore pages. So when we put the expectation of finding the most relevant handful of rulings, then we are actually asking to search a needle in a haystack. With all humility, I do wish to say that with our very scientific and logical software, it does enable such a search throughout the database in a very quick and easy manner. People who use the SEC Online would testify to the fact that it works in that fashion. By an interactive process, and this is the very important part of the software, that once you get a search, you can go from search within search, and in this interactive process, you are able to go to access the relevant case law, and it can be achieved within a time span about 20 to 25 minutes if one is used to accessing SEC Online. And also, now one can compile and print a whole brief with SEC true prints of the relevant judgments. It is a matter of some satisfaction that the SEC Online citations of high courts are also finding place in many judgments of the Honorable Supreme Court. Side by side, EBC has developed the EBC Reader, which enables easy access to commentaries and textbooks and bare acts, again in the most convenient and easy way. In the end, I would like to say to Abhijeet that since he can convey his thoughts so lucidly with clarity, he has a great future in the field of legal writing, and I do wish him all the best. In the end, I wish to thank all the dignitaries on the dais and the learned members of the bench and bar, ladies and gentlemen, for sparing your time. Thank you all.
Sir, for your kind words. I would now like to invite Mr. Rajdeepak Rastogi to deliver his address.
Namaskar. Honorable Mr. Justice Ajay Rastogi sahab, former Judge Supreme Court, he does not require any introduction because everybody, we know him fully well as a human being, as a judge, as a legal luminary. And I have got some special privilege that he is my brother. Honorable Mr. Justice Jain sahab, I always found Justice Jain sahab, when even as a lawyer, sometimes you were appearing against each other. And a lawyer who was well prepared, I can say, thoroughly prepared. In one or two matters, even I remember, he assisted me also in income tax matters. And I never knew income tax much more. But he was thorough, I can say. So, he is there. Honorable Mr. Justice Manish Bhandari sir, you all know his acumen, his qualities, and everything has been said. But now the relevance, he is very relevant today, I can say. Because once we talk about ED, we talk about money laundering, then we cannot forget about the Appellate Tribunal. Certainly we cannot. And we are fortunate enough that Honorable Justice Bhandari, who is well versed in all laws, I can say, and particularly now he is dealing with SAFEMA and PMLA. He is here. Shri Surendra Malik sahab, I was just asking Malik sahab, probably he did not recognize me, but I could. Because as a young lawyer, I used to go to Lucknow bench in some case where I assisted Shanti Bhushan in a transport case. Whenever I used to get free early, my passion was, I don't know how it was, to go to 34 Lal Bagh, if I am not wrong. It was EBC. And Mr. Malik, he was there, his father was there. I remember him. And I have a strong and very deep passion for SCC. The day I joined the profession, though I was not having enough money, but still I used to borrow certain books from my senior friends, senior lawyers. Then on installments through some booksellers here in Jaipur, I could arrange SCC in parts. So still as on date I read it. Now it is in digitized form, total digitized. Otherwise also it is on the printed form also. My young lawyer, my brother Abhijeet, and Abhijeet, I have got a special affection for Abhijeet because his maternal grandfather, I very well remember, is senior lawyer R.S. Rolia sir, and he was junior to my maternal grandfather, a stalwart, late Shri Radhakrishan ji Rastogi. So it's a family bonding also. When he came to me with a book, Money Laundering, so he was under a total wrong misconception. And it was told that I know money laundering. I say I do not know it, I am learning. I have got only A to B. Beyond that I don't know. And when in 2014 I joined as ASG here, very frankly I conceived the joint director and additional directors, the ED department, they were in my office. I very plainly said I don't know money laundering. So you have to teach me. Then they deputed one assistant director. It's all fact. He is here only. Now he is retired. He used to come to my office and teach me daily like a teacher. The provisions, only 75 sections, 3 schedules. Learn much, but A and B at least I know, not beyond that. So far as money laundering, everybody is just scared. I am saying it's not a thing to be scared. It is an act to deal with the criminals, hardened criminals who are economic offenders. and how the advent of the money laundering was. Because money laundering, it's a total concept based on international deliberations. Friends, I can say very well that if I am not wrong, it was somewhere in February 1990, to be very specific, 23rd February, that United Nations General Assembly meeting was there. A detailed discussion of all members. You can very well imagine the importance of this law. Internationally, globally, it was discussed to deal with the problem of proceeds of crime, POC. And then it went on, nothing was done, and 98 came. And it was 10th of June 1998 when a need was felt by all the state members in UN that we should have some national legislation in coordination with each other globally. And then 2002 Act is there, of course, it is called 2002, it received presidential assent, we know it in 2003, but it came into force on 1st of July 2005. Earlier, it was not, it was like a teethless act, I can very well say. Then by this time, probably 7 or 8 amendments are there. And 2013, if I am not wrong, is the main amendment, which made the law as practical law which could deal with the economic offenders. So money laundering, what is laundering? Laundering is nothing, we all know. It is an act how to put the bad money into circulation. So it is a part of the economy. So it is laundering, putting the bad money into circulation. And for that the prevention is there. Very salient features are there, very limited provisions are there, 75 sections total, really, they are there. But they are very effective, and from time to time changes were there and amendments were there as and when need was felt. And then even Honorable Apex Court took a view in so many cases, and top of it, the Y.S. Jagannath Reddy, I very well remember, and Mohanlal Jitamal's case, that these are the offences which are to be dealt with a different yardstick, because these are the offences which are committed with a designed mind, with a calculated approach. Other offences which are there, then Chhagan Bhujbal, I remember earlier cases, nothing was certain. Then Vijay Madan Lal, the Honorable Apex Court gave it. First case, Vijay Madan Lal was not there. So it is a reported case. And Shyam Sundar Singhvi's and Ashok Singhvi's case, the first case. Then it was held. Certain judgments are missing. So I'll be giving him certain judgments because we have a compendium. So he will be adding, but his work is excellent, I can say. It is probably the first book on the subject which is in such a concise manner, which consists of almost all the judgments of Supreme Court and High Court. So अभिजीत, आप बहुत बधाई के पात्र हैं कि आपने इस उम्र में आप मेरे पास आए कि आपको आना है, तो आप मनी लॉन्ड्रिंग में, मैंने कहा नहीं वो गलत है, मनी लॉन्ड्रिंग एवरीबडी इज ए लर्नर एंड दैट टू आई एम ए प्राइमरी स्कूल लर्नर इन मनी लॉन्ड्रिंग, आई डोंट नो मच अबाउट इट बट आई ट्राई, एवरीबडी ट्राइज. ये कानून बहुत अच्छा है, बहुत चेंजेस इसमें समय समय पर आएंगे. माननीय न्यायालय है, ट्राइब्यूनल्स हैं, हाई कोर्ट्स हैं, सुप्रीम कोर्ट है, दे आर टेकिंग केयर wherever some flaw is there, they are taking care, they are giving us guidance. And the subject, certainly, I can say it's an emerging subject. And looking to the economy, present economy, the development, these offences, they will be keeping and going towards a higher side. They will never be reduced because it's a human nature. मैं बहुत हृदय से धन्यवाद देता हूँ कि अभिजीत ने मेरे को बुलाया, और आप सब मेरे ब्रदर्स एंड सिस्टर्स, मेरे वकील साथी, अन्य लोग जो हैं मौजूद हैं जिन्होंने मेरे को बोलने का मौका दिया. मैं हृदय से आभारी हूँ।
Gentlemen, it is now time for the momentous occasion that we have all been waiting for. I would like to request the dignitaries on the dais to please release Money Laundering Prevention, Law and Practice by Mr. Abhijeet Sharma. Copy of the book. I would now like to request Justice Samir Jain to address the audience.
Good evening, everybody. Today is Friday, and I know it's a Friday evening. I have to be very precise and short, and that I will be. My mentors on the dais, Justice Ajay Rastogi, Justice Bhandari ji, Additional Solicitor General Rajdeepak sir, author of the book Abhijeet Sharma, and Mr. Malik, the publisher and the chief editor. Well, the law is at the virgin stage. There are divergent views, conflicts in the judgments are there, judicial opinions are different. It's a classic example of a blend of civil as well as the criminal side. The authorities which are taking care are either police department or revenue authorities, which is called ED. There are two approaches to it. One is adjudication on the civil side after issuance of a show cause notice. And the other side is a criminal side, which is type of a preventive detention. A very moot question here is, which was considered in Vijay Madanlal, was whether there has to be first an adjudication on civil side and thereafter a criminal proceeding or whatsoever. That is what this book, a pioneer work, is addressing to. The grey areas are very well captured and answered diligently. The young boy, young person, a young lawyer has made a start and he has done a lot of work. I think the book deserves a big round of applause, and I request all of you to stand up and just encourage this young man. He has done a good work. The sphere that Mr. Sharma has touched with his wise knowledge and hard labor is not something there has never been heard of, but something which is fetching towards the most severe concerns of the day. The offence of money laundering is a problem of great magnitude in the present financial globally, being negative economic impacts even locally within our country. From the late 20th century, the issue of money laundering has travelled through various ways and names, whether it be the fear of Chinese rulers, because of which the then merchants hid their wealth, or the modern techniques of hiding, circulating and laundering criminal money, or the underhand activities of hawala, though which money may be transferred from one location to another, often without the actual movement of currency. As a consequence of the present issue, which made its presence felt in our country a long time ago, the Prevention of Money Launderers Act of 2002 was enacted in conformity with the international standards to fight against the criminal offence of legalizing the income profits from some illegal sources. It enabled the government to confiscate the property earned from illegally gained proceeds. That was a sea change. A preventive attachment was introduced by this act. The ultimate goal of all judicial members is just to eradicate the general motive of money laundering that prima facie in most cases seems to be for the funding of terror activities, organized crimes, drug cartels and human trafficking. That was the major act, and that's why the act was made very draconian and criminalization of the act was done. Though it is a fiscal law, but only on these terrorization, criminalization, organized crimes, drugs were involved, this was given a criminal shape. I personally of the opinion that this issue is a grey area which is yet to be read and understood more in order to create some effective preventive measures and levy punishments. And this endeavor of Mr. Sharma has not only expressly elaborated the genesis of the misdeed, but also carries extensive coverage and a unique blend of narration of international experiences with money laundering acts of different developed countries alongside the provisions of Indian PMLA with suitable commentary. While concluding, I feel delighted to preface that this book shall enlighten all the readers regardless of their elementary or advanced knowledge on the subject. All my good wishes and heartfelt congratulations to Mr. Sharma for his publication. The editorial needs and the publisher from Eastern Book Company also needs a big round of applause for encouraging the young writers.
Thank you for enlightening us with your words. I would now like to invite Mr. Justice M.N. Bhandari to address the audience.
My esteemed brother, Justice Ajay Rastogi, my brother, Justice Jain, Senior Advocate and Additional Solicitor General, Rajdeepak Rastogi, publisher of the book, Surendra Malik Sahab, and author of the book, Abhijeet. I'm really delighted to be part of the release of book authored by Abhijeet, a very young and talented boy, a lawyer who came to me to present the book, I think, a month back. It was to my surprise that a young guy can author a book on a very complicated subject. Why I would be saying the complicated? Because it is amazing law, the law which is taking shape. The prevention of money laundering, the word laundering that has been given meaning by Mr. Rajdeepak Rastogi, and the background of it has been given. But you would be surprised to know from where this word has come and how this prevention of money laundering law came. In fact, it was only to address the drug mafias, and that was spreading in US. In US, the biggest problem for the drug mafias, how to use the proceeds of crime, the money earned out of the crime. It was a big issue for them and a big problem for US government. How to tackle these problems. Many things were pondered upon, thought of, but criminals were very clever. They had taken opinion how to use this money, how to convert proceeds of crime into the money which can be used fairly in a legalized manner. The idea was given to open laundering machines, to install laundering machines, and whatever money is generated out of it, that can be used as a legalized money. So whatever is used or earned out of the drugs business, that was put by installing the laundering machines. You would be laughing that how laundering machine can generate the proceeds crime to be legalized money, but it is a reality. And the government could not address the problem because it was affecting not only the economy but the people at large. Drug business was spreading in US like anything. The subject was put in the UN, and with joint efforts by all the countries to address not only the money earned out of the drugs, but every money earned out of the proceeds of crime, which was the biggest problem was even the terrorism. The money was used even for generation of the terrorism. The UN Convention, a decision was taken that all the countries will bring a law to address the money earned out of the proceeds of crime, or it is a proceeds of crime. Out of the International Convention, the Government of India framed the Prevention of Money Laundering Act 2002. The legality or the constitutional validity of the law was challenged and addressed by the Supreme Court in Vijay Madan Lal because it has peculiar facts or the provisions of law. Burden of proof generally in the criminal cases lies on the prosecution, but here is a case of reverse burden. The criminal has to prove himself to be innocent, and therefore prosecution is not burdened to prove the case, though prima facie case is to be brought. Now the tribunals have been set. The crime is committed, it is affecting the economy of the country, and to address that, 29 legislation were kept under PMLA Act. That whatever is the predicate offense, that is the offense, under different acts, whatever money is generated out of it is to be protected. The difficulty was that if somebody is committing a fraud with a bank, how to protect that money, because it's a public money, it is to be used for the country. And for the first time, a proper mechanism was developed to forfeit or to attach the property of the person who is involved in money laundering. I would be saying money laundering because it may be that he is not involved in the predicate offense, but if money is coming to him, his property can be attached. And this remains subject to final outcome of the case, criminal case, that is the predicate offense, and even the case under the Money Laundering Act. A very peculiarity is that here the criminal case is tried on two fronts. One is the predicate offense, which may be IPC or any other law, which would be tried either as instance of the CBI or the police, and simultaneously the second trial is by the ED. Therefore, two simultaneous trial is permitted for the first time, almost for one and the same offense, though the offense under the predicate offense would be different, and offense under the money laundering would be under section 3. These are few features, and because I am taking up the matters under the PMLA Act or many other economic offense, so it was really valuable for me to look into the book, and I must say the book has been released, but I am using it for last a month because it is very precise. Everything has been dealt with so properly and accurately that it will give answer to every issue which is relevant to the case. I congratulate a young author and at the same time the publisher. I would say Mr. Malik has reposed confidence in a young author because publication of the book may not be easy, but I would give credit to Surendra Malik Sahab also to have given his room for publication of this book. The book would be useful for every lawyer, and I must say, you are working in the field of law, but now is the time to work in the specialized law also. The PMLA is again a specialized law, and not only criminal cases, the matters coming, as Mr. Samir Jain, Justice Samir Jain has said, it has two facets. One is the criminal side and the civil side. Both are there in the PMLA Act, Prevention of Money Laundering. Civil side is basically attachment of property, and those who are working in the criminal side would know that the provision to attach the property exists even in the CRPC, though not used. Section 105 makes a provision for attachment of property even if it is a procedural crime in the crime under the IPC or under legislation. But that is not being used, and therefore a complete framework was given under the PMLA to attach the property so that if one is convicted, the property or the proceed may be given to the person who has been cheated. For example, we have come across to the frauds with the bank. ED has been criticized, but I would say they're serving for the cause of nation. The fraud with the bank is not of few crores, 5, 10 or 15, 20 crores or 1,000 crores. The cases addressed by us is running in 10,000, 20,000, 30,000 and 40,000 crores. It can take care of economic of a small country, and that is the volume of money laundered in one case, and it is mainly arising out of the bank fraud. Now this is the public money, it is required to be protected. Once the property is attached, ultimately if the crime is booked, the criminal is convicted, the money, whatever is the property attached, would be released in favor of those who have been affected by this crime, maybe the bank or anyone else. One part has been touched, that whether private person can also lodge a case. I think Malik Sahab, this is very relevant. See, I mean, there are two parts, predicate offense as well as the offense under the PMLA. Predicate offense is what is schedule offense. That is under 29 different legislation under the PMLA Act. Any individual can lodge an FIR for commission of fraud or anything which is predicate offense, and thereupon the enforcement director can register the ECIR and investigate the case, and the money laundering case can be started. It would be basically to protect the money. I once again extend my gratitude to Malik Sahab and Abhijeet for inviting us on a very momentous occasion for release of book authored by Abhijeet, a very young and talented lawyer who has covered all the relevant aspects of the book and made critical analysis of the book. I would give one suggestion to Abhijeet, that we author the book, make the critical analysis in reference to the provisions, but we don't make suggestion about the legislation, defect in the legislation. If the many acts are looked into, we find legislations to be little defective. The author is required to make a comment what are inherent defects in the legislation, and why I am saying so. If there remains any defect in the legislation, it gives rise to litigation, because there would be many interpretation of a provision. It is not clearly and properly worded. And we know the litigation is mounting in our country like anything. If years together is taken, the litigation cannot be cleared without a new registration of the case. So author is now required to look into, for PML itself, because we are addressing this law every day, the defects in the legislation required to be pointed out so that it may go to the government, and if the things are required to be taken up, necessary amendment can be brought. Though Mr. Rastogi has said that amendments have been made. It is not only in 2013, but I say it was in 2015, 2018, and recently also an amendment in 2023 was made to include many such persons who are not directly involved in the crime, but suggesting the commission of crime, which includes the chartered accountants. Though advocates have not been taken in the sphere of money laundering, and that should not have been, but the scope has been enlarged for that. So at the end, again, I extend my thanks to Abhijeet and the publisher of book, Malik Sahab, for inviting us, and I hope and trust that Abhijeet would keep on writing in the same manner, and only, not only on PML but on many other relevant proper work would be not only the interpretation but comment on the legislation. Thank you once again. Thank you.
The chief guest for today, Justice Rastogi, to deliver his address.
Yes, you feel comfortable and you can do something else other than the law. But still, your presence itself give a strength to Abhijeet and all of us that we are concerned about the law on the subject, and particularly the emerging subject like the money laundering. Thanks to all you are present here. My brother Justice Bhandari, we have been together from the day one in profession, came on the bench, and today we both are before you. My brother Justice Jain, an emerging lawyer and a very dashing judge, I have been told, in the court also. Good. Sabi, please do it and keep it up. My brother Rajdeepak Rastogi, he is energetic all the time, even inside or outside the court. And I can tell you one thing, people sometimes feel that he becomes slightly harsh sometimes in court also. But at the core of his heart, he is very soft, very humble, and commitment to the cause of justice is unparalleled to him. Rajdeepak, I always congratulate you. And he as a lawyer appeared for JD a number of times, and even before me, when I was judge here, I asked him, Rajdeepak, these are all matters goes on, but he was committed that no, any injustice caused to the JDA in any capacity was not acceptable. Good. Mr. Malik, who is providing so much of assistance in getting it published, and the way the SEC finder is working, the Supreme Court cases is one which is now considered to be one of the authentic book, acceptable at all stages. And even in the Supreme Court, there was a time earlier when SCR was the only journal which was cited in Supreme Court. But SCR, with all respect, has not kept the pace of time taken up by the Supreme Court now, Supreme Court cases. And it is the only authenticated journal which normally in the Supreme Court judges demand. No other journals. Earlier Scale and other journals were there when you were here. But all journals by passage of time have been lapsed. And because SEC finder doesn't want to leave any stone unturned in reference to the code of conduct and the law on the subject, so they are going ahead. And I'll tell you one thing for this SEC. They launched their SEC online somewhere in 1994. And I was the first subscriber to SEC Finder when they are giving us a CD which is replaceable by 3 months, every quarter. That was the way by SEC Finder has worked. Now see the changes. Now single click, every information is being filtered down to you and available on your command. My good wishes, Mr. Malik, you are doing a good job. Last but not least, Mr. Abhijeet Sharma. When he has given this book to me, I had not come across the book earlier. I have extensively read the book. And I find the kind of a comparison which he has made, putting all judgments of various courts, with the Supreme Court, although I find no difficulty in saying the views are very conflicting. The screen is very smoky as on today. It will take some time to clear that screen, but still, Abhijeet has put in labor to find out how the things can be streamlined and put in order so that it may be more workable, more acceptable, and people may use this book for the betterment of the cause of justice. And one thing more, law books are normally used by lawyers and professionals. But this act, every walk of person in the walk of life will be using this book. The law students, the lawyers by their profession, the government and the enforcement directorate for being a prosecutors, and a victim also is now using this book for the betterment to know where the fault lies and why I should take care of prevention. Because this is prevention of money laundering. So if I have to prevent myself, I must know where I am going wrong. So if I take that cause and prevent myself from taking a cause that I should not indulge myself in money laundering as being under the statute, I'll be safe. But still, I'll tell you one thing. This act has a fear in the mind of the people. Tremendous fear. And when I put a question to myself, I find that anyone who has earned money, I'm again saying earned money, he always even the fear, God knows, any fine morning somebody knock the door of my house and say, please, I am the ED, please come with me. Because in ECIR, we don't want to supply. We don't want to provide him a material. We don't want to provide him what is the cause, what is the material against you for which we are being here before your court. In FIR, the people have this, ECIR not. But the problem is, which I am not been able to clarify myself, if this is not to be supplied, person is not known, you take him to custody. Now you say burden is on you. My question to myself is, from where he is able to discharge the burden lies on him after being arrested. So what I feel is, either by a judge-made law or by an amendment, there must be a synchronize. Undoubtedly, this is a legislation which affects the economy of the country. It's a financial crime. No one is going to save it. If we want the economic health of the country, it has to be dealt with very sternly. Undoubtedly. But to my mind, we have to balance the financial health of the country on the one side, the right of liberty which is protected of an individual on the side by the Constitution. Now, if we can't synchronize both on a parallel way, God knows what will happen. I was just looking forward on the Google subject to correction. You may also get a correction on this. The present data which is available on the Google in the last 5 years, which comes to 18 to 23, 3,867 cases are registered at various places under the anti-money laundering laws. And in the last 10 years, because this act has been now to 18 years, 31 PMLA matters are decided. And 3,867 matters are registered. Now see the dilemma. If this is the system we are going at, what will be the outcome? And I have taken one more data for consumption for Mr. Rajdeepak being a prosecutor and dealing with the matters to protect the rights of the people as well. People who are for 1 year inside in custody, they are 63,502. 2 to 3 years, it comes to 33,980. If you go beyond to 3 to 5 years, it comes to 25,869. And see the figures, above 5 years, 11,448 is the figure. See. And if you synchronize the punishment is up to 7 years. I think the latest amendment has been made. For some, it has been 10 years in 23. Now the question is 7 years is the punishment, which is maximum, up to 7, not 7. People are incarcerating under trial for 3 years, 5 years, under the presumption that I have to prove myself. The burden has been shifted in the ordinary course of business. Where we are going ahead. My request is, we must look into that and synchronize. As I earlier said, and I repeat, we must deal with sternly. There should be no room of discussion. But at the same time, liberty of an individual at no cost should sacrifice. How it is possible to synchronize? It is for the legislature to examine. And if not, the judge made law which we always interfere and passes orders. And I share my experience. The time has come now, every bail application landing to Supreme Court. We had a slogan earlier where the Supreme Court said, bail is the rule and jail is exception. Now I was reading just now, there was some judge in the Madras High Court, how brilliant the man was. He said in PMLA, there's the reverse right. I recently, they were saying, what we are doing it? We are taking this nation to which side? something has to be done. And Abhijeet has put everything in a straitjacket formula and collated the material for your consumption, for your interpretation, to examine as to whether whatever the act and its implications are, and when we come for implementation and execution, how it is possible to mention that the law must be upheld, which has to be, but at the same time, individual rights to be protected, which we are mandated to. And that we have, as a lawyer, as a judge, has taken oath, which at no cost should sacrifice. I always say that we are all learners. We learn every day, as a lawyer or as a judge. We examine the provision every time. And whenever you examine, next time you'll find that there is some refinedness in your approach, clarity in your approach. So my request to the lawyers is, please read the provision as and when it comes to you, as number of times as you feel convenient. And don't take an impression that I've already gone through it number of times earlier, why should I look into it now? No. Because every time when you go and interpret, you will give a different dimension. You will think over that, no, my approach was not that clear as I was expecting earlier. Because in a court of law, we have not examined these matters more. When we examine section 47, where the burden is on the accused himself, the Supreme Court has struck it down earlier. But by some cosmetic amendments made, again they are put in. It is true that in Madan Lal's they have been upheld, but I think two different points, particularly for ECRs not being made available, the right of the accused, and for two other matters, review is pending and notice was issued when I was there. I am a firm belief that laws have to be implemented strictly in the true sense as the wisdom of the parliament is, because they are the will of the people. But every act has to be synchronized in a manner which make workable and effective, for which we are committed. What I feel is now, gravity of offence has predominant. Oh, 5,000 crores. I failed to convince myself first how gravity of offence is in any manner material. Because what you are stating today is all prima facie. Tomorrow if you find him guilty, he will be somewhere else. Now, gravity of offence has predominated in rejecting bail ordinarily in all cases, as a matter of course, which my understanding I have not been able to persuade myself. This is one area which I request that they must look into and find out a better way which make the system more effective, more acceptable. People are not interested to commit defaults. Common man is not interested in committing crime. He doesn't want to do it. Sometimes exceptions are there. People do deliberately. They must be dealt with very sternly. But I said, there are scheduled offences and there are predicate offences. Now if you charge him under 120B with 3 or section 4 of the PMLA and put him inside, God knows what happened to his health. Where 120B will not hold him guilty in this fashion. If somebody commits an offence of fraud, 467, 471 is there, magistrate will grant him bail immediately after 1 month of his custody period is over. Nowadays it's not there, because 467 is also landing to the Supreme Court. But if somebody put PMLA inside, God knows what happened. My request to the members of the bar, please come forward. See that the matter is being dealt with sternly in reference to economic offences. But at the same time, the interpretation may be harmonious, may be constructive, may be in the interest of people at large. Because ultimately we are dealing with the plight of a common man. We are not dealing with ourselves. If we are not able to deliver justice to a person who is knocking the doors of the court, I think then we are not doing our duty as assigned to us. You lawyers are very energetic, I think. And I know most of the lawyers who are present. You are the only watchdog who the people are looking forward. And you alone can put the matter in the right earnest before the court, which may make the system more logical, more acceptable, for which we are here. And if we are failing our duty, we have to introspect ourselves. Where we are losing, where we are unable to persuade and clarify to the courts of law that here the shoe pinches to us. Because you people know the ground realities. You can decipher between the right and wrong. We can't do it. This is the way by which the system works. This is the way by which we all work in our respective fields. Now see, the appellate tribunals to which my brother Bhandari is the chairman. You hold that man inside the bars on the one side, attach the property. God knows which property belongs to which. And I tell you one example which came to me. That man purchased the property in 1998. I still remember the date. And he was taken to custody in 2021. And 98 property was said that this money has been circulating yourself because they say continuing offence. And that man was inside. And property was also attached. 98, I still remember. I was shocked. I passed a jail order. I said what may wrong is, you can't put this property into your attachment at no cost. These are not continuing offences. Now the problem is the man is squeezed from all sides. Becomes beggar by time. He has to be dealt with sternly, I say. I repeat, sternly. No excuse. But in a manner which is acceptable to law. In a manner which is acceptable to the society at large for which we are working. And I always say laws are meant for the society. Society is not meant for law. You have to make the laws in a manner which is being infused in the society by acceptance. If the law is not workable, if the laws are not giving effective results which man the society, then those amendments are made, and that's why we made always amendments under the laws. So again repeat, and I say Abhijeet has done a wonderful job, please do it all the time. And my suggestion is only one. Commentary is by the author, but you may have a tabulation as to what are the judgments, in what form they have been given, so that it may make convenient to a lawyer that in a given facts and circumstances, which particular judgment will appeal him to persuade the court. God knows persuasion is there, not very difficult to say for me, but still, lawyer can do his endeavor to find out, to persuade the judge at least that this is the facts and circumstances in which this is the law on the subject delivered by the High Court or by the Supreme Court. And that will be a more easiest way for putting the matters into order. So I'm very thankful for giving me this opportunity. This book will certainly give a long way for the people, and go on writing these books all the time, and give me this opportunity as and when you get it sometime else, and I'll try to see that the things roll in the manner which is acceptable to us. Thank you very much.
It is now time to invite the man of the moment, Mr. Abhijeet Sharma, to share his words.
So you're not audible.
Honorable Justice, Honorable Mr. Justice Rastogi sir, Honorable Mr. Justice Bhandari sir, Honorable Mr. Justice Jain sir, ESG, Ajay Rastogi sir, Surendra Malik sir, members of the bar, ladies and gentlemen, I take it as a singular honor and privilege that this distinguished panel has graced and is present at the release of my book. I couldn't have urged for anything better. My deep gratitude to all of you as such. I am also grateful to all the guests for gracing the occasion with your kind presence. The topic of money laundering has always been of great interest to many, including me, ever since my college days. The generic three-stage process of money laundering, that is placement, layering and integration. Placement, where the dirty money or the proceeds of crime first enter the financial system. Layering, which involves a web of transactions which are being done in order to conceal and obscure the origin of illicit source. And the integration, at which stage the previously laundered money enters the legal, lawful economy. When I started working on this book, I found that not much is available on all these three stages of money laundering process. The book contains the in-depth analysis of all these stages of money laundering process, along with appropriate multiple examples, which I believe is very necessary for a comprehensive and wholesome conceptual understanding of the subject. Technology is a double-edged sword. Technology permits us wonderful new opportunities, but at the same time, it can also be misused. The benefits of, with the advancement of technologies, with the advent of technological advancements, the speed at which the banking transactions, banking transfers can be made, the amplified volume of such transactions, and the reduced costs at which such transactions are made also appeal to another sector that is of organized crime. One full chapter is dedicated to the concept of cyber laundering, virtual currencies, and digital payment systems, with risks posed by them and the steps which are being undertaken to combat them at the national and international level. Any law book on money laundering would be incomplete without a section-wise commentary on the Prevention of Money Laundering Act. As Honorable Justice Rastogi in the data referred to by him, last couple of years have seen a surge. There's been a tremendous amount of surge in the actions taken and the prosecutions launched under the provisions of Prevention of Money Laundering Act. And consequently, there's also an increase in the number of cases which have been reported. The book contains all the relevant cases on the subject which have been decided so far. And if the missing cases which Rastogi sir was referring to, I'll make sure that they are included in the next edition of the book. The role of various statutory and regulatory bodies such as RBI, SEBI, IRDI, and the anti-money laundering AML guidelines which have been issued by them have also been included in great details in the book. Money laundering in various other sectors such as NGOs, NPOs, real estate sector, in sports, trade-based money laundering, in the insurance sector, etc. All of them have been covered in the book. Justice Rastogi also referred that the recent amendments, by the recent notifications, certain activities of the professionals have also been included have also been brought in within the ambit of the Prevention of Money Laundering Act and the rules made thereunder. Money laundering is an activity which cannot happen in the absence of professionals. The predicate crimes which are there, obviously they are not the ones who are laundering the money. The role of professionals is there, and they have been brought within the ambit of Prevention of Money Laundering Act, recently only. I thoroughly enjoyed writing this book. I hope that the readers get as much as I did by writing it and by putting it together. Thank you so much.
Subject. What an evening it has been. An event and as enriching as this one cannot come to an end without returning thanks. I would like to request my colleague and friend Ms. Nilofer Bhateja to deliver the vote of thanks.
We hope our audience was enlightened and entertained by listening to the words of wisdom of our esteemed chief guest and our guests of honor today. First, I would like to thank Justice Rastogi for agreeing to be the Chief Justice and for agreeing to be the Chief Guest and for releasing the book. Next, I would like to thank Justice Bhandari, Justice Jain, and Mr. Rajdeepak Rastogi for taking out time from their busy schedules and for gracing this occasion. To the author, Mr. Abhijeet Sharma, for trusting EBC to do justice to his second book, and to also wishing him many more publications from our end. And last but not the least, to Mr. Surendra Malik, the chief editor of SEC Online, who in his more than 50 years of legacy has taken SEC to greater heights. We would like to thank him for attending the event and also for his constant support and mentorship. Last and not the least, also the team that put together this event, to Ms. Prachi Bharadwaj, to Bhumika Indolia, Parveen Banu, Mr. Sanjay Suman, who alongside me were instrumental in putting together this event. To the EBC team behind this book, the legal editors, the copy editors, DTP professionals, and the citation teams. Also, the sales and marketing teams who will truly take this work to the readers. I would also like to thank the media houses for covering the event, namely First India, Dainik Bhaskar, and Rajasthan Patrika. To the organizers, HCM RIPA team, for helping us in hosting this event. And last but not the least, to the wonderful audience for being with us on this momentous occasion. With this, I would like to declare the end of this event, and I would also like to request all our panelists and our esteemed guests in the audience to proceed for high tea in the garden area.